Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors legal hotline lawyer. And today's video falls under the heading of breaking news for property managers. To the extent you have been imposing any kind of a tenant screening ban with respect to a tenant applicant's criminal past, you need to stop that practice going forward. The Washington State Attorney General has recently filed a lawsuit against a property manager in our state based on exactly that conduct. That because a disproportionate number of African Americans and Hispanics are incarcerated for felonies, it creates a disparate impact on African Americans and Hispanics for residential property managers, landlords, to screen tenants based solely on a criminal history, including felony convictions. There's nothing in the current opinion that limits the analysis to felonies excluding sex offenders. Let me say that differently. There's every reason to believe that the same analysis which makes it a risky behavior for a property manager to screen applicants based on an applicant's prior criminal history, including felonies, the same risk exists for the property manager who screens tenants based solely on the tenant's prior sex offender convictions. If you as a landlord or property manager intend to impose any kind of a restriction on tenant applications based even on a case-by-case review of a person's criminal past, all I can suggest is that you seek legal counsel before you do that. It may be possible on a case-by-case basis to impose that scrutiny, but it's not entirely clear that you can do so even on a case-by-case basis. This is a difficult issue, it's a complicated issue, and it's a departure from the way it has always been. Never before have we taught that you are prohibited from screening tenants based on prior criminal history. If you have questions on this topic or any other, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.